Good morning, everyone. Welcome to day 4 of the Singapore Convention Week. We hope you are enjoying the diverse range of events and topics so far. My name is Karen, and I'm the Chief Strategy Officer at Maxwell Chambers. We want to take this opportunity to thank you for joining us this morning for our 6th session of the Maxwell Conversation. In partnership with Dentons, Maxwell Conversation brings together leading personalities in international dispute resolution, aiming to challenge assumptions with deeper examinations of issues on various topics. This year's theme is managing public policy. And we have together an excellent panel of speakers with us this morning to share their insights on this very topic. I will now hand over the mic to our moderator, Lawrence Tay, Global Co-Head of International Arbitration at Dentons, who will introduce the theme and our panel of experts. Over to you, Lawrence.
Thank you, Karen. Good morning to our physical and online audiences, and welcome to this special Singapore Convention Week edition of Maxwell Conversations, where we challenge assumptions with a deeper examination of the issues. Public policy is important in determining the arbitrability of a dispute and also a ground on which an award may be annulled or refused enforcement. It has often been said that public policy should be construed narrowly in keeping with the pro-arbitration policy of the New York Convention and the UNCITRAL model law. Perhaps less mentioned is how arbitrator independence and seat court review are so fundamental and universal that they form part of the, quote, international public policy, unquote, of arbitration. In contrast to such an international public policy is the different notion that the court can enforce an award that has been annulled by the seat court if it regards annulment to be against the enforcing court's own public policy, whether it relates to crime, sanctions, corruption, bankruptcy, sovereignty, or other concerns. Are the notions of international public policy and state public policy the opposite of one another? And can an enforcing court consider as part of its own public policy, 1, international public policy, 2, the public policy of the country of the governing law, 3, the public policy of the country of the seat of arbitration, and 4, how to resolve conflict between different public policies. Our leading personality is Dr. Michael Hwang SC, who is known to all and one of the world's leading arbitrators. I shall have a conversation with Dr. Hwang, after which we will be joined by 3 individuals who are at the top of their game, both as counsel and as arbitrator, namely Jessica Fei, Sae Youn, and VP Singh. They too are well known, and their particular achievements may be found in the publicity materials for this event. As you, the physical and online audience, listen to the speakers, you may wish to develop an interesting or challenging question to put to them. If so, for the audience here in the room, please submit your questions by scanning the QR code that you will see on screen. For the online audience, you can submit your questions directly via Zoom, via the Zoom Q&A function. Let me start by turning to Michael and asking him what's been occupying him recently.
Well, sorry, is my mic moving?
Yes.
I've asked for a guide to put us on the right track to deal with questions concerning the topics we're discussing today. For those of you who are not familiar, the best starting point to look at anything to do with the New York Convention is to look at the book which is in the center of your slide, the ICCA Guide to the Interpretation of the New York Convention, which has been around for several decades and is constantly being updated. And in fact, this year, the 2nd edition was launched in ICCA Hong Kong. So this is the really up-to-date short guide to questions of interpretation of the New York Convention, which I highly commend to anybody who wants to start, or even people who want to update themselves as to what are the latest trends, because it gives you a quick bird's eye scope of general views in the major jurisdictions where arbitration awards come for enforcement. A deeper study is another book which is very neutral and very authoritative because it is a semi-official explanation of the convention by UNCITRAL. So sometimes people don't understand or are not aware of the history. UNCITRAL is not responsible for the creation of the New York Convention because UNCITRAL wasn't born then. So it predated the UNCITRAL, but UNCITRAL is the official guardian, in effect, the representative of the UN to keep the convention up to date, and therefore are in the best position to explain it. And two of the most distinguished jurists in this field are the editors of this volume. And then for a really deep dive into the specific topic of today's discussion is the public policy exception, which is a monograph by a very respected Austrian arbitrator, Anton Maurer, whom I happened to bump into in the Shangri-La on Tuesday. And I said, would you like to come to this? He says, well, I'll be in Seoul right now. You want, give me a long distance call. And there was actually a very interesting event. When I was in Dubai and serving as Chief Justice of the DIFC courts, I participated in an international conference, and my brief was to run a session on the public policy exception, where representatives from the neighboring countries would all come and contribute. So because it had a Middle East focus, I had judges from Egypt, Lebanon, and UAE. And then I asked to bring in Anton Maurer because I knew that he was a specialist on this, and Anton very kindly came. And then the three judges gave their points of view, and then Anton gave a kind of academic and deep study view of how interpretation should be done. So these are three guides to all of you to follow up.
Great. Thank you, Michael. Turning to the topic today, a core requirement for recognition and enforcement under the New York Convention is an award whose subject matter is, quote, capable of settlement by arbitration. Conversely, an award that contains subject matter that is not capable of settlement by arbitration may be annulled or refused enforcement. Michael, is this concept of capability of settlement by arbitration an international concept or a concept that is specific to each contracting state?
I take a sort of very blunt view, and that it really is an international concept, but with national characteristics, as the Chinese like to say when they discuss arbitration in their country. Yes, we follow international standards, but with Chinese characteristics. So the New York Convention is something like that. It's international, but there are national characteristics. That's the short answer to your question. But I think certainly if you read those books that I've referred to you, it's meant to be an international concept. But when it comes to enforcement, then the enforcement court may have national characteristics.
Well, I mentioned this topic of capability of settlement by arbitration because one often sees it mentioned together with public policy. And my next question is, how different is the concept of capability of settlement by arbitration to the concept of public policy? Are they really the same thing? Are they two different things?
Well, again, if you take a deep dive into the history of the convention, and this is a general advice for anybody who wants to study conventions, you have to go back into what the French call the travaux préparatoires, which are the minutes of the meetings that discussed each and every section of the convention, and then it's up for debate among all the national delegations. The history of this particular distinction between arbitrability and public policy is recorded that at one point, the French delegation wanted to strike out arbitrability and said it's going to confuse people. Of course, the French are very good, with due respect, at confusing people themselves, but that's another story. But what is significant in historical context is that the French asked for it to be struck out, and the delegation just refused. Everybody refused. So everybody had the concept. It's a different concept. That's why you have 5.1a and b.
Right. But yet, I mean, if you humor me, Michael, yet you see in arbitral legislations around the world, arbitrability defined as that which is not against public policy. There isn't a specific reference to capability of settlement by arbitration. That's conventional language. But if it's defined in that way, that something that's arbitrable is something that's not against public policy, then one shades into the other, doesn't it?
No, I think it's easy. To me, I find it relatively easy to draw a line in terms of classification. Arbitrability is actually more of a technical issue. It's not capable of being arbitrated because the inherent nature of the dispute itself is such that you can't solve it, or you should not solve it by arbitration. And the main justification for holding that something is not arbitrable is usually not so much public policy, but public interest. And it's a generic thing rather than a political decision. So most countries are agreed some things, certain areas are not arbitrable. And one clearly defining factor is where you have to invoke a state agency to make good the relief that you're claiming. So since the state agency is not a party to the arbitration, the state agency cannot be bound by a decision by an arbitration or a court, yes, because the national state agency has to obey the state court. But a national agency does not have to obey an international arbitration award until it's converted into a local judgment, right? So you think that's why there's this argument about anything to do with real property or, well, not so much immovable, any property that is registrable in a public register. Those tend to be not arbitrable because you need to invoke the assistance of the state. But actually, if you really think deeply into it, it is also slightly, it's a sort of a shortcut to bar cases because I used to do a lot of property disputes. And in property disputes, you're arguing about whose name should be on the register. We go to court and you fight it in court and you never ask for an order that the court, that the agency recognizes. You will tell the parties, you have wrongly put yourself on the register. The court order the wrongful party to make good and go and remove the register or correct the register so that the true owner is reflected. And that can be property, land, or maybe things like patents and so on. Anything that has a register, trademarks, and requires removal, you can actually have an in personam order issued by the court, which has teeth, because you fines, your imprisonment ultimately. So it is not a 100% distinction, but it is usually, in practical terms, the clearest and easiest guide.
You mentioned earlier this morning that your view that the concept of capability of settlement by arbitration is international in nature. It overlaps with another question that I have, which is that arbitral conventions are said to carry with them a pro-enforcement policy, and it has been said by courts around the world that the ground of public policy must be construed narrowly. Does this not also suggest that public policy is not purely state policy and that there is an international or universal sense to each state's public policy?
Depends on who you're talking to or which country you're talking to. Some state courts take the view this is against international, against public policy, and they just don't look beyond the words and said, obviously public policy, the state courts are the guardians of public policy in our country, therefore we should apply our local standards. And then that's why you have organizations like ICCA who go and try and educate the judiciaries. I mean, that is actually the sole purpose of ICCA, is to educate judiciaries around the world about the true meaning, interpretation of the New York Convention. Lucy Reed, our ex-chair, is there, and she'll be happy to, supplement this, I'm sure.
Thank you. I'd like to turn our attention now to the rest of the panel and put particular questions to them. I'm going to begin by asking Kim Sae Youn. It is well known that a ground on which awards may be annulled or refused enforcement is that enforcement is against the public policy of a state. But to what degree must the award offend public policy? Is it enough that in performing the ordinary transaction, the parties are engaged in something objectionable to public policy, or must the objective of the transaction itself be objectionable to public policy? Sae Youn?
Thank you, Lawrence. Good morning, everyone. Nice to see everyone here so early. You have to appreciate that we came even earlier, and we hope everyone's awake by now. We just discussed that the public policy exception is usually in most jurisdictions, hopefully, accepted as something broad, something more narrow than the public policy of that particular nation. So it has to be something what we call international public policy, and something that is known as violating a very basic notion of justice and justice. So that's that if you apply that principle, there may be a transaction that's normal, that has no problems, but the parties were involved in questionable actions in carrying out that transaction. That would not be enough to meet such threshold. So it's the objective of the transaction itself that has to be questionable in order to qualify for exception to public policy. So things such as corruption or bribery, or maybe in some cases, almost some things related to gambling, paying money in order to have the gambling become available. So those type of transactions themselves have to be objectionable to qualify for exception of public policy. And if I may add, there's not necessarily the transaction itself, but what about if the award was obtained through fraudulent actions? Even in such cases, I have a judgment back home in Korea who said the Supreme Court of Korea set the rules. Even if the award was allegedly obtained by fraudulent actions, the applicant who is arguing that has to prove three things before being able to set aside the award. One, the fraudulent action has to be proven with objective and clear evidence. Number two, the party who is arguing fraudulent actions had to be unaware of those actions during the arbitration due not to the negligence of the party. And the third one is that fraudulent action has to be materially related to the issue of the arbitral issue in the arbitration, which is a very high standard to meet. And that actually shows, I think, the courts are very reluctant to set aside the award or refuse enforcement based on public policy.
Great, thanks. I'm going to reach out all the way to the other side to VP and ask VP perhaps to be controversial. Supposing the transaction is ordinary, but the parties went about performing it in a really heinous fashion, what do you say? Would there be a public policy ground for annulment or refusal of enforcement?
So I come from a jurisdiction which is more look in than look out. So we would give it a look in to see whether the objective of a transaction is to defeat, is to actually defraud or beat a tenant of local law, but not just a simple infraction of our local law. So it has to be in design evasive, and that would be our trigger. So taking the case of fraud and how it plays out, in fact, I'm dealing with something which has a Singapore-India limb to it. And the essential difference in terms of Indian law is we actually call out to that as an express clause in our definition of public policy. The Singapore law, which is based on the UNCITRAL model law, does not call it out, but it does follow that. And the question comes down to, is this prescription driven towards parties or towards the court? And in our case, courts have believed that it's driven towards them. Therefore, they will give it, that's why I call it a look-in jurisdiction. They look at it because they believe that it's going to give them the answer. the standard is surprisingly very similar to the Korean standard. So while they may not be an international standard, but there is an a-national standard, which is effectively the underlying foundational basis for a challenge before Indian courts, especially for international awards. So our domestic awards, of course, we do have our own curry, but we have a light curry version for anything that comes in for enforcement from abroad.
Jessica, what do you say to this question? How much must the acts of the parties be against public policy?
I think, talking from the Chinese perspective, from the Chinese court, not necessarily, the performance itself, or if it is, for example, against mandatory laws of China, a Chinese party, that is not necessarily against public policy. I think it is the court's reasoning is more to consider not just the act itself, but also I think the overall objective of the transaction and the end results, whether that will actually really shock kind of, the basic notion of fairness or justice, or sometimes morale. So I think that's, of course, it might be slightly different in different jurisdictions, as mentioned by, I think, Sae Youn. For example, gamble is not legal in China. So a gamble debt might likely be against public policy, because it is that kind of transaction itself is illegal, and it is, I think, against the general kind of so-called concept of morale for Chinese. So that might be considered within that scope. But overall, another example is the Supreme Court has said very clearly, even if in one of the transactions, the Chinese party violated the mandatory rules to do certain approval and registration with the Chinese government, it executed some transactions overseas, but that's their violation itself. By violation of mandatory laws of China, when it coming back to China for enforcement, is not considered a violation of public policy. So that, as you can see, the court is not really saying anything against our law is against the so-called international standard Chinese public policy.
Thank you. Michael, the rest of the panel seem to have a commonality of views that it must be the design or the objective of the transaction itself must offend public policy before it can be a real ground for annulment or refusal of enforcement. Do you think that's the right position internationally, or the right sense that we should have internationally about public policy?
I don't know that national courts have specifically focused on mens rea, if you like. Suppose they perform a transaction which unknown to the parties is illegal. So, they actually didn't have mens rea, but it so happened that it violated, a national law. I don't think that's what the New York Convention is talking about. Let me just take this opportunity. I was just mulling over my notes as I was thinking, and I thought it might be helpful to give a guide to people who are new to this topic, and you want to find out where is the sort of starting point for research in each individual country. Where do you start to examine the law of public policy? So, I had done some miscellaneous notes. So let's say we don't have a UK lawyer on this panel, but in UK, for example, if you're interested to start on this topic, there's one case which all of us learned in the old days. It still gets quoted. It's called Soleimani and Soleimani. So you start from there and then you move forward. Then there's another case called Westacre. So these are the two cases. Then if you sort of start doing research on this, then it'll take you on to many other things. In America, the leading case used to be a case called Chromalloy against Egypt, which is a very interesting case. And about 20 years ago, I gave a talk at an ICCA conference on this case. It was hot off the press. Since then, I'm told that American courts have not consistently followed it or not. But the one interesting takeaway point from Chromalloy, which I want to just commend to you, is this. The American court which heard that case was enforcement of an award which had been set aside by the seat court, which was Egypt. And then the argument was you should not enforce it because, Egypt did something bad by booting out all the foreign workers. I think it's, during the Suez crisis. And all the Americans were sent back, who worked on the project were sent packing back to the US. So somebody argued before the US court, this is against US foreign policy. And the US court says, US foreign policy is not the same as public policy or US public policy. It's a memorable kind of statement. But again, that gives you a starting point. And then the French, you have to be very careful because the French have an actual statute that says that they don't have to comply with one part of the US, of the New York Convention. And so you have to be just, and so they have the right to enforce a judgment which has been set aside. So, these are things that, and of course, in France, the case law doesn't matter so much, but there's also a very famous French case called Hill-Martin. So you just remember Hill-Martin, and then you go on from there.
Okay. I'll put my next question to Jessica, first of all. Western European and North American courts have taken the view that enforcement of an award may be sought, even though the award has been annulled by the seat court, if it can be shown that the annulment proceedings violated the enforcement court's own public policy. On the other hand, other courts take the view that an award that has been annulled ceases to exist and cannot be enforced. Do you have a view on which approach has more to commend?
Thank you, Lawrence. I think that's actually a question really, while Michael was talking, actually reminded me of my early day thesis for my master's degree. It was on Article 5 of New York Convention. And these cases, these old cases actually mentioned by Michael was actually written about that these were the cases out there to, I think, to start the discussions about whether a annulled award can still be recognized and enforced. And I think the more I practice and understand law, actually, I find it more perplexed. If you starting with a question, if an award is set aside, we are legally trained, I think the starting point, you go to the arbitration law of that particular seat, right? It is lex arbitrary, and the arbitration proceedings is seated in a jurisdiction. For example, Singapore's award here is Singaporean, although it is, you can say international arbitration award, but every award has a nationality. That is actually prescribed by the national law and international convention, like New York Convention. So I think, and this particularly if for civil law trained lawyers, it will be more kind of confused. If an award is set aside by the seat court, I think the starting point, it should be null and void ab initio, right? That is actually what we have been told or taught at law school. So then actually, this started the debate by the US court case and French court cases. And actually, we just checked actually before this event, any other courts that have really recognized, enforced, annulled awards, actually probably not so far, is still limited. But the debate on the enforceability of an annulled award has continued, and I think has attracted more and more kind of attentions. And I think that's as the starting point. I think we'll probably, if you go to law school, it's probably it will be complicated if say yes, it's null and void ab initio. So that means it should be considered as never existed. So as you say, non-existent, then how a non-existent award be recognized and enforced by another court in a different nation? So that is actually, it's a little bit, people will be puzzled, at least to those who have been legally trained. And then in principle, it shouldn't be, enforced elsewhere. That's, I think that's the starting point, because if, let's say, Court of Singapore is trying to say an award from India, try to recognize, has been set aside in India, nothing offensive against India though, then the Indian court say this award should be treated, has never been there. And then if Singapore court says, I don't agree with the Indian court, I'm going to recognize, enforce it. So the starting point is another court thinks the decision of another nation's court is wrong. So that's why I can ignore it. That's, I think, is the natural logic, right? And that actually, if you think about international law, there is a concept called international comity between national courts. Then, so it is a little bit difficult to appreciate if agree international comity should be accorded to another court's decision. And because the party has chosen, let's say, Delhi as the arbitration seat, they are subjected themselves to the jurisdiction, to the supervision of the Delhi court in that sense. And then how you could, another foreign court can say, it is, I can ignore these choice, and including the risk of such choice. I think as a starting point, they will be very, very difficult to understand that perspective. So, and also, of course, if an annulled award can still be recognized, enforced in some jurisdictions, it will create quite unstable or uncertain status of that award. And as we see, there have been some, I think, stories going on and drama going on. People are trying to enforce an annulled award in different jurisdictions and try their luck. So whether that is something desirable, I think, people may think from what perspective. I think you may think differently. If you are the winning party, you think, yes, definitely I have my second chance, at least to try somewhere else. So I think in general, although it's not necessarily my personal view, I'm not really, also disclaimer, not view of, my firm or this community. And I think it's just, just talk about the general kind of understanding of this issue. It shouldn't have, be there unless because of these international cases, around. And I think gradually people are thinking there are also some good points with that kind of argument. There might be cases where it is so extreme that you want to consider using that. For example, if the court that set aside the award is really against, the general kind of international, human standards or, human rights very, very severely, you may consider, the other courts might think this is just so unfair. I think that might be the kind of extreme and limited instances where the court may consider to disregard another court's decision.
Thank you. Michael, you had a question for Jessica.
Jessica, China has a unique system for enforcement of awards. And I thought the audience would appreciate it if you explain that system.
Okay. Yes, I think China has been, although there are many kind of misconceptions about enforcement status in China, but actually the Chinese court, at least from the Supreme People's Court, that's the highest court in China level, it is very pro-enforcement. And as early as in the 90s, the Supreme People's Court has set up an internal reporting system for any applications where the local courts is minded to refuse enforcement of a New York Convention award, for example, and including other domestic foreign related award. It has to be reported to the provincial high court level first and up to Supreme People's Court. So how it works is only until all levels of courts consent to the non-enforcement, it can be refused enforcement. That actually reduced the number of any potential non-enforcement. And if you check the case law or the precedents of non-enforcement from, that has been approved by the Supreme People's Court, it's very, very small number. Some years you may even have zero.
So that way you get consistency in the Supreme People's Court, right?
Generally, I would agree with that. As I think, as we have discussed, the court is also composed of individuals. So I think institutions like CTAC have been trying to talk to the court and the judges in charge of enforcement and trying to persuade them what is the so-called international standard and to construe the public policy standard, public policy exceptions in a narrow sense. So generally, yes, as you can tell, how difficult non-enforcement can be achieved in China.
And all these cases on enforcement go to one court in particular, Supreme People's Court number 4, right? And number 4 has got specially chosen judges. In fact, I think all of them are supposed to be theoretically at least bilingual in English, right? And my personal experience is that the ladies are much more fluent in English than the gents, probably for historical reasons. But so yeah, it's really and so the consistency and these several of these judges have been educated overseas, so they are quite international,
Yeah, I think that's very true. And so that's why actually I've seen these cases where the Chinese court, at least, because you hear about all applications about non-enforcement on public policy grounds, it is always that, right? The applications will be made on that, including that basis, including that ground. But if you look at the actual cases, the final number of cases that have been supported is really, really limited.
I'm going to turn to Sae Youn and then very quickly after that to VP on this question. Do you have a reaction to what Jessica has just said? Perhaps on what she has referred to about international comity and the language of the courts to observe Comity of Nations.
Yeah, from that perspective, that's one way to look at it. And I actually conducted a research in 2017 and wrote a paper on that regarding 8 jurisdictions within Asia. And at that time, although there were some opinion by some scholars about the possibility of enforcement of annulled awards within Asia, at least in the 8 jurisdictions that I looked at, Singapore, Korea, Japan, China, Hong Kong, and then India, Indonesia, Vietnam, Vietnam and Malaysia were the 8 jurisdictions that I looked at that time. None of the courts had enforced until then an annulled award. And the reason I started that research was because of the clash of the Singapore Titans that happened in 2015 when Chief Justice Menon gave a speech on the enforceability of annulled awards, and he took what we call territorial approach of saying what Jessica just said. An annulled award in the seat is no longer existent, so it cannot be enforced elsewhere. To which then SIC President Gary Bourne, opposed, and he said it should be transnational approach. The arbitration agreement is the basis of giving the arbitration award the life, and he said it should be enforced regardless of whether it has been annulled at the seat. And that was really prompted my research. And until that time, it was so, and I understand that Korea and Singapore are still have not still enforced any annulled awards. So there is actually different thoughts, and Asian countries seem to be reluctant in enforcing it.
We come the other end of the spectrum, and it's because we end up annulling awards rather than looking at enforcing annulled awards. And the 2 places that you've seen that happen recently is Davis, where you had an award which was otherwise being enforced by 3 simultaneous jurisdictions being annulled by the Indian court. And it went into the underlying fact that the company had been set up for fraud. And that is a separate conversation, and maybe that's a seminar by itself. But the issue that we've seen is, would a court enforce something? And the answer to that is there needs to be an award to enforce. Unlike the French, and as Michael correctly points out, the French use Article 7 of the New York Convention, which allows a nation to opt out and have more restrictive grounds. Therefore, a transnational approach like in Putra Bali is something that may actually play out. And while we did our research on this, because it finally got us thinking, who all have done it? And it was a very interesting list of countries that have enforced, largely American and European. France, Belgium, Austria, US, Canada, Netherlands, and England. And you can see that these are jurisdictions that actually are what you would call jurisdictions of commerce. They're jurisdictions that are likely to face problems in case they allow for local jurisdictions to determine how it plays out. So if you were to ask me, is there a baseline standard? I would say that there isn't a definite baseline standard, but if you were to put it this way, once an award comes in, you will hear courts more or less respond similarly. But depending on which part of the world you're in, your court will respond similarly to its similarly situated countries. So Gary's position that it has to be a transnational standard may not be a transnational standard across the world. But there is a transnational standard, but it's just more block-wise. That's how I see it. And I don't see an Indian court actually going ahead and enforcing an annulled issue. We did have that issue come up in the context of res judicata and issue estoppel when Republic of India versus Deutsche Telekom came up before court, yeah. Because it was an award which was looking at a second ping. The first shot had already happened in Switzerland. You saw that the court here in Singapore said, while I'm minded, I will see it, but I will apply my own mind to it. And I think that's the right standard to use, very frankly.
Thank you. Now, Vijayendra, if you stay where you are, my third question is actually posed to you. What kinds of public policy do you envisage that courts should take into account when determining annulment or refusal of enforcement proceedings? They obviously take into account their own national public policy, as they should under treaty wording, but what about taking into account the public policy of the state which has a close connection with the dispute, whether it's governing law, place of performance, place of enforcement, perhaps?
Let's walk down this. There are three buckets to it. The first bucket is morality, because you should remember, it's something that offends morality. The most obvious answer or example of that is apartheid. So if you had if you had to enforce an award which had something which gave preference to an apartheid position, trafficking, you will find Indian courts definitely coming out and saying no. You'll find any court, any civilized court coming out and saying no. The second piece that you will find is the issue which Michael spoke of in passing, of what is in personam versus in rem. Anything that goes and gives status cannot be outsourced. And in most jurisdictions, that will be the one place that you'll find courts becoming more, for the lack of a better word, grabby, or more circumspect about opening that out to a private determination. The third piece that you will find is something which is out and out criminal, not regulatory, but not mala prohibita, mala in se. So something that can by no jurisdictional yardstick be said to be right. Let's take an example. I'm going to try and sell the idea I try to sell on the convention of, say, a hack, which is not an ethical hack, taking place. You get the information in that hack, and that is the basis of an award. If you have helped procure that hack, for instance, would a court come in and assist with the enforcement, though it is based on what some people may say is the truth? The answer is possibly no, because it would violate the fundamental tenet of fairness. So you do have a baseline that comes about. It's a standard which is going to be based on status, morality, and last but not the least, fundamentally towards the objective behind the transaction. Does it dress it up or does it present it as it is? And if you've got what I call the tadka or the seasoning at the end of criminality, I don't see courts across any jurisdiction turning around and saying, you're welcome to my court and I will give it a stamp of approval. I think these are classic standards where people will possibly look at it.
Sae Youn, and then quickly after that, Jessica.
Yeah, I fully agree with what BP has said. Two other examples that may not directly come to your mind as public policy issue, but actually is a public policy issue is actually res judicata and payment of the award. So if the award is against res judicata, means the same case, res judicata of another award or judgment, then in that case, the award that comes later and is against the res judicata can also be refused enforcement based on public policy issues. And the other one, as I said, the payment. If an award is out and it has already been paid, but still enforcement is sought, courts would apply public policy exception to reject the appeals.
Yeah, I fully agree with the comments I've made. It's actually, I think it looks like we have certain consensus on these, what are the factors that should be considered in terms of enforcement. And I think that is actually universal to a certain extent. Although, you have to recognize although, we're trying to uniform certain of the standard of enforcement or application of public policy exception, it is actually it started as, the court will have their own view and consider the issue under the circumstances that they are brought to. As I think correctly pointed out by VP, is very much, it can be, one thing might not be offensive to some people, could be very offensive to others. Like, for example, when it comes to religious issue and certain issues of their basic kind of a value and belief actually can be really different. And we also see the cultural difference and other things. So the international standard or understanding is also need to be modified or adapted to the local standard, because that's why you are seeking enforcement in a particular location. That's why the court has the right to review to a certain extent. And I'm just thinking loud, if the New York Convention didn't start as with providing the local court's role in these review, it would have never been agreed, because no court will, from the beginning saying, I will subject myself to something I don't know or has yet to be agreed in clear, terms, then I will subject myself to. I think that's actually very, very true. And just thinking about, as I explained, the non-enforcement, statistic in China is very, very low, but among the very few non-enforcement case based on public policy that has been has gone up to the Supreme People's Court and been approved, are two cases involving the conflicts. The decision are considered conflicting with prior Chinese court decision. So that, I think the court's view says it, it actually is contrary to the judicial sovereignty. I think that in these circumstances, the court tend to be a bit more, I think, sensitive in, trying to say, you foreign arbitrators, foreign tribunal, how could you say my decision is wrong? And this is a Chinese law issue. I think, but it depends on the timing. If it's a prior decision, rather than, because then actually the tribunal has the option by knowing that decision already, rather than, it is something, the different sequence, actually, I think we have cases either way. The prior decision of Chinese court, actually, it is not enforced. But if it's post or later, then actually it doesn't affect the enforceability.
Thank you, Michael. I'm going to ask you to round up our conversation on this topic. Does it mean that there's no end to the kind of arguments that one can advance on public policy to a national court to say, look at the public policy of a different country, there's some connection here to this dispute, look at, or is it ultimately something that still has to be focused on the state's own inherent declared public policy?
Well, when we first encountered this topic, all the textbooks written in English anyway will say you start from what is the meaning of public policy, and it usually is international public policy. And the starting point is usually, I think it's a US Supreme Court decision called Parsons and Whitmore, Parsons and Whitmore, which says it's not just your national interest, it's the fundamental grounds of societal behavior or tolerance. And then that's been picked up in Hong Kong. And the Hong Kong judgment gets more traction simply because it is a Commonwealth case. And it was a very strong court because it was the final court of appeal. And the person delivering the judgment was a retired senior judge from, was it Australia or England? I think it's of the UK. But he cited Parsons and Whitmore. And again, he repeated the same thing. If it's contrary to national public policy, it doesn't mean to say it's against international public policy, which is, in general words, but the deepest foundations of morality that a state should tolerate. But there's an interesting twist on that. For Singapore, we had a fairly recent case called AJU, and I think ATU, and there was a transaction in Thailand, governed by Thai law, I think, yes. And then basically it was a deal to settle a dispute which was actually against the law of Thailand. And they didn't report it to the police. So subsequently, when the guy defaulted on the settlement, sued to enforce it, got an award, and then they came to enforce in Singapore. And the first judge in Singapore said, well, it was an agreement to stifle a prosecution under Thai law. This would be against Singapore public policy. And therefore, I refuse to enforce. Went on appeal to our Court of Appeal, and our Court of Appeal said, we are not concerned with people making wrong decisions under a foreign law. If they had made, because the chosen law, the governing law was Thai law, so they are saying that the finding under Thai law was wrong. We're not concerned with mistakes under Thai law, even if it violates the public policy of Thailand. But if you make a mistake about Singapore law in a foreign arbitration, you come to Singapore and enforce it. That engages Singapore public policy. So we only engage our own public policy when it is our law is the governing law of a foreign arbitration.
Great, thanks. We do have time for one or two questions, and one of the interesting questions would be, should the meaning of commercial dispute under the New York Convention be expanded and modernized? I mean, we were talking earlier about the limits of public policy, but is there, this is a very interesting question. It approaches it from another angle. Should we perhaps redefine or better define commercial dispute so that the boundaries are clearer? I'm going to start with VP, Sae Youn, and then Jessica.
So the reason why I took this up was investment treaty claims have been tested in Indian courts, and we've treated them as being outside that definition. So maybe that is something that may be considered, at least for inclusion, at least from an Indian standpoint. And otherwise, you need to figure out how are you going to deal with regulatory state intervention, which is now getting into more commercial areas, especially with technology coming in. And we don't have a real or ready answer to that. The courts in India, of course, have taken the view that commercial is as broad as it gets, excluding just taxation, matrimonial, criminal, and what they would call hard-coded sovereign matters. And what is hard-coded sovereign matters? National security, integrity of the nation, and relationships with international governments. So leave that aside. I think everything else is kosher.
Yeah, there's this discussion when we were amending the Korean Arbitration Act about what would be the scope of arbitration agreement, back returning to the arbitrability issue. So the concept that was discussed was whether it is about an interest or right that you can dispose of yourself. So I think that ties in with commercial. Commercial can mean a lot, but at the same time, commercial does not mean that it is involving an issue that should apply to everyone. And that is like the registered rights, if whether a patent is valid or not. So those type of things, although there would be a commercial agreement arising out of that damages claim, those are arbitrable. But the actual something that you cannot dispose of as a party to that transaction is something that would fall outside of commercial. That's what I think.
Jessica.
I fully agree with the discussions. And I'm thinking actually, I think along the years, the commerciality of disputes or what are commercial disputes have been slightly and gradually expanded to some extent. For example, except what have been discussed, IP disputes. I think that was actually traditionally considered something different from general commercial disputes because it relates to registration and other, title or ownership. But I think gradually because under Chinese law, there has for court cases, there has always been, you have to specify what your case is. It's a breach of contract case or an infringement case. In Chinese court, you have to pick. You can't say this is breach of contract and infringement normally. So you need to go down one route. And typical, I think traditional people have been thinking infringement, torts case are not, commercial to a certain extent. But I think, as we have just discussed, as long as it is some right that can be agreed and disposed of between private commercial parties, and sometimes not even commercial parties, because we're talking about commercial, even like, government body or organs that are engaging in commercial activities are considered commercial party, right? So I think, people have been expanding the idea of commercial, what is commercial, but generally in arbitration, it has to be, because we always have the arbitration agreement restriction. Normally you cannot expand beyond that. So that's why actually, as long as the transaction covered by the arbitration clause is primarily regarded as commercial transactions, and including it can be infringement torts involved and can be both, arbitrable by arbitration. So I think the concept has been expanded, but in relation to investment arbitration, I think that is still most, courts, national courts would not accept it is a commercial award under the New York Convention. So that's why it is not really enforced and under the New York Convention. It's an exit convention, it's differently. Because you ask a court, a national court of particular state to recognize and enforce an investment award against its own state. I think that will be, unlikely to be considered commercial.
Michael, perhaps a new project for ICCA, redefinition of commercial dispute?
No, you can go into the historical archives for Singapore. I don't see anybody of my seniority in the room, but when I was practicing, and when Singapore was a colony, we didn't have time to pass a whole lot of commercial statutes. So we had a sweep-up clause saying in all cases involving mercantile law, we will import the law of England as it stands on that date of the case. So there was some argument of what do you mean by mercantile, 19th century English. When, all businessmen were just merchants. Anyway, so our courts quickly decided that mercantile equals commercial. So we had a lot of case law about what you mean by a commercial case. And then there were two strands. One was analyze the law. Is it a commercial law or is it not a commercial law? The other strand was analyze the situation. What is the situation a commercial situation? And if you do, then you apply the same law as would apply, even though you are applying non-commercial cases as such. Give you an example, age of majority. That applies to all sorts of things. But in the commercial context, then there is an age of majority act, but if not, then you don't. And then you go back to common law. So most of the international conventions do have definitions of commercial, so you have to stand by that. In Dubai, when I was in DIFC courts, we had an interesting situation because when we started, our best customers were employment disputes. So we had a lot of cases about employment. Then one day, people from the Dubai side says, under Dubai law, employment is actually not commercial. I think English law would tend to favor employment disputes as being commercial because it's for services rendered for which you get payment. The US will have a different view, and US specifically, I think, exclude employment disputes out of the definition of commercial, which is why sometimes employment cases are not arbitrable in the US because they don't come under commercial arbitration. So it depends on the context in which that term is used.
Ladies and gentlemen, I hope you've enjoyed this special edition of Maxwell Conversations. Will you join me in thanking our speakers, Michael Hwang, Jessica Fei, Sae Youn, and VP Singh?